Next up, we've got the United States Court of Appeals for 7th Circuit, Federal Trade Commission versus Credit Bureau Center and Michael Brown. Michael Brown is the sole owner and operator of Credit Bureau Center, a credit monitoring service. We refer to both collectively as Brown. Brown's website uses what's known as a negative option feature to attract customers. The website offers a free credit report and score while obscuring a key detail in a much smaller text. That applying for this free information automatically enrolls customers in unspecified $29.94 monthly membership subscription. The subscription was for the credit monitoring service, but customers learned of this information only when he sent them a letter after they were automatically enrolled. Brown's most successful contractor capitalized on this confusion by posting Craigslist's advertisement for fake rental properties and telling applicants to get a free credit score from Brown's website. So that's a nice trick. So Brown basically said, if you want to get rental property, you have to get a free credit score. By the way, you can get it from here. And by the way, we're going to charge you $30 a month. But if you do that, nice trick, nice little scheme you got going there, right? The Federal Trade Commission eventually took notice. It sued Brown under Section 13B of the Federal Trade Commission Act, alleging that websites and referral systems violated several consumer protection statutes. The Commission sought a permanent injunction and restitution. Relevant here, the district court found that Brown was a principal for his contractor's fraudulent scheme. In other words, he was the man behind the scheme. He was the guy directing the scheme. And the websites failed to meet certain disclosure requirement in the Restore Online Shopping Confidence Act. The judge entered a permanent injunction and ordered Brown to pay more than $5 million of restitution in the commission. Ouch. Ouch. Brown now concedes his liability as a principal for the contractor's Craigslist scam, and he doesn't dispute his own website failed to meet some of the disclosure requirement. So we have no trouble affirming the judge's decision to hold him liable for both. We also affirm the issuance of a permanent injunction. Brown's argument there rests on an erroneous understanding of the Eighth Amendment's excess fines clause. But the restitution award is a different matter. By its terms, Section 13B authorizes only restraining orders and injunctions. But the Commission has long viewed it also as authorizing awards of restitution. We endorsed that starkly atextual interpretation 3 decades ago in a prior case. Since that case, the Supreme Court has clarified that courts must consider whether an implied equitable remedy is compatible with an express remedial scheme. So in other words, the Supreme Court has said, look, if you're going to say there's an implied equitable remedy, you must look to the first what the statute's legal remedies are. And if there's a legal remedy, you have to decide whether it's compatible or not. And the Supreme Court has specifically instructed us not to assume that a statute with elaborate enforcement provisions implicitly authorizes other remedies. So just because there's other things doesn't mean it implies a particular alternate remedy. Applying these instructions, we conclude that Section 13B's grant of authority to order injunctive relief does not implicitly authorize an award of restitution. Every reason they gave for not finding an implied monetary remedy applies here. Most notably, the FTC has 2 detailed remedy provisions that expressly authorize restitution if the Commission follows certain procedures. Our current reading of Section 13B allows the Commission to circumvent these elaborate enforcement protections and seek remedy directly through an implied remedy. Stare decisis cannot justify adherence to an approach the Supreme Court precedent forecloses. Accordingly, we overrule Amy Travel and hold that the section does not authorize the restitutionary relief. Because the Commission brought the case under 13B, we vacate the award. So that $5 million award is going bye-bye. In January of 2014, Brown contracted with Danny Pierce to direct customers to his credit monitoring service. Brown gave Pierce several functionally identical websites with names like eFreeScore and FreeCreditNation.com to use for referrals. As their name suggests, these websites invite people to sign up for a free credit report and score. But signing up for that free score also automatically enrolled applicant in a credit monitoring service, which charged a monthly subscription fee. Brown didn't tell prospective customers about the credit monitoring service. His website almost entirely focused on the free credit scoring report. 3 disclaimer, buried in much smaller font, told customers that applying for a free offer also enrolled them in an unspecified membership that cost them a $29.94 per month fee. Customers also later learned the subscription was for credit monitoring when Brown sent them a letter after the automatic enrollment. Pierce did nothing to clear up the confusion. Indeed, it's undisputed that the method for drumming up referrals was fraudulent. He subcontracted with Andrew Lloyd, who posted Craigslist advertisement for non-existent rental properties at bargain prices. Lloyd invited prospective tenants to email the landlord. Posting as the landlord, he then responded and instructed them to obtain a credit report and score through Brown's websites. But once applicants got the free information, they were automatically enrolled in credit monitoring service. Lloyd stopped responding to emails. Nice touch. The plan was effective. Pierce quickly became Brown's most successful recruiter. Over the course of the relationship, Pierce referred more than 2.7 million customers to Brown, generating over $6.8 million in revenue. That is a lot. Unsuspecting customers were understandably upset. They flooded Brown's customer service operations, questioning the monthly subscription charge. They complained that Craigslist advertisements were scam, and they were blindsided by the fact that requesting a free credit score automatically enrolled them in a costly credit monitoring service. Brown told his customer service team to deny any involvement with Pierce operations, and although Brown typically agreed to cancel for future charges, he often refused to issue refunds. He also obstructed his representatives to offer reduced prices to retain customers. Some customers accepted the offer, but others told their credit card companies to cancel the charges. Credit card companies canceled more than 10,000 of the charges. It's a lot, too. Customers complained to the Commission, which opened an investigation. In January 2017, it sued Brown under Section 13B of the statute, seeking an injunction and restitution. The Commission alleged that the Craigslist advertisement violated these provisions on unfair and deceptive ads or trade practices. The suit also alleged that Brown's website violated the same provision of a different statute. On the Commission's motion, the judge issued a temporary injunction, froze assets, and appointed a receiver to manage his company. Ooh, ouch. So basically, you appoint someone to overtake the company to administrate it. That's rough. Brown and the Commission later filed cross motions for summary judgment. In addition to contesting liability, Brown argued that Section 13B does not authorize an award of restitution. Alternatively, it does not authorize penalty or legal restitution as opposed to equitable restitution, which regards tracing a plaintiff entitlement to a particular account or fund. The judge ruled for the Commission across the board, holding that Brown violated the statute as a principle for the scheme, and the websites violated different statutes and rules. The judge issued a permanent injunction that imposed extensive conditions on Brown's continued involvement in credit monitoring industry and ordered Brown to pay $5.3 million in restitution. He also denied Brown's motion to unfreeze his assets to pay his attorneys. That's also rough. Brown contests his liability, the permanent injunction, and the restitution award. Different standards of review apply. For liability, we review the summary judgment standard from the beginning. The Commission sued under Section 13B of the statute, which by its terms authorizes temporary restraining orders and permanent injunctions to enjoin relief of the federal trade law. To impose individual liability on the basis of corporate practice, the Commission must prove the practice here violated the statute, or the individuals directly participated in deceptive ads, and the individual should have known about it. Based on this record, the judge held that the Brown violated the statute. While Brown concedes liability for the scheme, he challenges his liability for website violations. He asserts his websites contain no misrepresentations in violation of statutes. He also argued the Commission must enforce the statute through internal adjudication. It is unnecessary to consider every theory of liability. Brown challenges to the injunction restitution award do not turn on what statutes he violated. So we start and end with ROSCA, which restricts the use of negative option feature to sell goods or services on the internet. ROSCA prohibits the feature unless the seller provides text that clearly and conspicuously discloses all material terms, obtains the consumer's express informed consent before charging, and provides a simple mechanism to stop recurring charges. There's no dispute that Brown used a negative option feature to enroll people in the service. The only question is whether he complied with the statute disclosure requirement. In the afterwards of the district courts, the websites were virtually devoid of any mention of the service aside from a statement that the customer is to be billed for it. Moreover, Brown conceded that this implied disclosure behind more prominent language offering the free score report. Brown focused on the conclusion disclosures weren't conspicuous. He parses font size, details his color schemes, and takes a microscope to the affidavits in an effort to highlight evidence that consumers read and understand disclosure. But he gives only passing attention to decisive points. His website did not provide certain information that it requires. This oversight is fatal. Brown next contends that even if corporate liability is established, he should not be held personally responsible. But it's undisputed that he controlled the websites and he was aware of their content. That's enough to establish personal liability. The judge held that the conduct warranted a preliminary injunction. We do not need to decide whether our standards for injunction also apply to this standard because Brown's challenge does not turn on that question. His injunction largely relies on the excessive fines clause. He contains the injunction is unconstitutionally harsh and disproportionate. But he skips the necessary step, whether the injunction is a fine at all. It's not. The Supreme Court has limited fines to cash or in-kind payments. So injunctions are not covered by the Eighth Amendment. Fair enough. The bulk of the Brown appeal challenges the restitution order. The preliminary injunction section does not authorize restitution. The FTC gives the Commission several tools to enforce the practices. A final cease and desist order empowers the Commission to sue for legal and equitable relief, but only if a reasonable man would have known that the conduct was dishonest or fraudulent. It is other enforcement mechanisms. The restitution against this order relies on 13b. We start with the obvious. Restitution isn't an injunction. It's not. The Commission does not seek to argue otherwise. Instead contends that the statute implicitly authorizes restitution. An implied restitution remedy does not sit comfortably with the text, considering the requirement defendant must be violating or about to violate the law. Regarding ongoing or immediate harm matches the forward-looking nature of the rest of the injunction. The Commission must also believe that enjoining an ongoing violation would be in the public interest. The public interest is stopped by preventing harm, but they're reading tied to an inopposite remedy of the inquiry. True, this appeal concerns Section 13b's permanent injunction provision, not the provision governing temporary restraining orders, which is tied to the subset. The absence of similar language in the section is conspicuous. When Congress includes particular language in one section but omits it in another, it's generally presumed Congress acts intentionally. Yeah. Remedial scope is the only difference between these sections. Section 13b does not offer any of the protections, and yet the Commission contends it provides the unqualified rights to the very remedies that other enforcement mechanisms do. Makes sense. The section serves a different forward-looking role, enjoining immediate violations and ongoing violations. That makes sense too. The Commission also suggests Congress ratify it. We disagree. In short, nothing about the text or structure invokes the implied right. So there is no implied right because it isn't in the text, and it contrasts the way the text structure is set up. So that basically makes sense to me. So as a result of this, if the FTC wants to get monetary damages, it has to go under one section. If it wants to do forward-looking stuff, it has to go under a different section. Now, of course, it can do both. They're not mutually exclusive. But the thing is, if you're going to do monetary sanctions, you have to go under a section that has due process and certain particular protections in place to, make sure that a person's fully heard before giving the award. The FTC tried to circumvent that by looking at their forward-looking authority and say, well, we can fine people under this too. And that's not right. Congress gave you the authority to fine people under one particular section, And so you can't look at another section and say, well, we have it here too. The very fact you have it one place means implicitly you don't have it in another place. And so that seems legally right. Unfortunate that this guy is going to, looks like he's going to get away with this in terms of the fines, unless the FTC reopens it to do their inquiry in terms of the financial stuff. So maybe he'll be held at the end of the day. But hey, Congress gave the law protections under law. They did, and they didn't under others.